Welcome to the Professionals of the Inland Empire show with your host, John Tulak.
Hello, everyone, and welcome to 2026 and yet another edition of Professionals of the Inland Empire. I'm John Tulak, your host. I'm an international business attorney located in Claremont. And this little adventure of mine is now moving forward into its 10th month. And I'm really excited to bring to you each week two professionals, usually, sometimes one, who are experts in their field and have something to share with you that will be important for you to know as business people in our Inland Empire greater community. And these are people that can help you in your business, help you grow, or help you get out of trouble and then stay out of trouble if that happens to happen to you. So I am happy today to welcome to the show Han Pai and Oz Tannenbaum. They are both lawyers. They both do litigation, but they do it in very different fields. Han is a business litigator with some emphasis on creditor rights, and Oz is a personal injury attorney. That's on the plaintiff side of the table. So, gentlemen, welcome to Professionals of Inland Empire, and ladies and gentlemen, help yourself to a slice of pie. Here's we go. So let's start with you, Oz. Tell us a little bit about yourself and who you are, what you do, how you got there.
Well, thanks so much for having me, John. I appreciate being here. A little bit about myself. I originally wanted to make a long story short. I wanted to be a garbage man, and now I went from garbage man to being a doctor, to want to be a doctor, and now an attorney. So I love what I do. I started out on the defense side of things. For about 12 years, I was an insurance defense lawyer, and so I was hired by insurance companies to defend against the very people that now I represent. On the plaintiff side, I learned a lot on the defense end of it, different strategies, tactics, how the insurance companies work, etc. And I use that to assist my clients now on the plaintiff side, where I help people who are really hurt in car accidents and vehicle accidents and bitten by dogs and trip and fall, and basically people who are hurt through the fault of another. And so now I'm a partner at my firm, Cohen & Swartzen, and love what I do, love being able to help people out.
So I had to start with you, Oz, because as a brand new attorney, I started with a boutique law firm that was on the insurance defense side primarily, Lloyd's of London, Fremont, and we had a bunch of trucking companies too, some of which were self-insured. But we also had started a plaintiff side of it as well. So I got to do both the first couple of years of my practice. So Han, tell us about yourself, how you got started and where you are today, what you do.
Thanks, John. Appreciate the opportunity to join the podcast today. So my name's Han Pai. I'm a business litigation partner at Cilician LLP. When I graduated law school, it was right smack in the middle of the financial crisis. And so the first firm that I worked at, they split between employment defense as well as some business litigation. I didn't care too much for the employment defense side of things and sort of leaned towards the business litigation side, which I found a lot more interesting. Had the opportunity to work on some cases involving creditors' rights, enforcing loans, deeds of trust, foreclosure litigation, which I thought was pretty interesting, as well as dealing with corporate disputes. Eventually made my way to my current firm, where I got the chance to do more of that type of work, along with all types of disputes within the commercial litigation space, which, as we all know, it can be pretty broad. So everything from your typical breach of contract, business torts like fraud, unfair competition, real estate disputes, everything, that kind of runs the gamut when it comes to the commercial litigation.
So more on the plaintiff side, would you say, Han, in your practice for you?
I say it's a mix of both. We handle both the defense side and the plaintiff side. And so I think that gives us some insight as far as, when we're on the other side and what the opposing counsel is going to do or not do. So we have a good sense of the moves and are able to anticipate that and use that to our advantage.
Yeah, and that's where I ended up going after leaving the first firm I was with. I came into a firm and my goal there was to establish a business litigation practice. And so I started moving away from the personal injury side on, although I still kept getting that work. And actually, when I left firm, the insurance companies came, and the trucking company in particular came with me, which for a young attorney, I was pretty happy about that because it was good business to bring to a new firm. So today, it's a different ball game. I stopped litigating some years ago, and I leave it to you younger gentlemen and women in the profession to handle all the things that end up in court, because it is a grind, to say the least. Let me go back to you. The plaintiff attorneys have to deal with a lot of stonewalling, especially when insurance is involved. The claims adjusters don't seem to have the kind of authority to freely settle cases anymore. They're controlled by their bosses. And so you can't engage with them the same way that I was able to do once upon a time.
Yeah, it's actually very true, and it's getting a little bit worse. Not even the defense lawyers, at least a lot of the ones that I talk to, they don't really have any power anyway. And the adjusters just really ignore them. And so they're looking at it from the standpoint of, okay, how much are we going to pay? And the real tricky thing is that no insurance company is the same. You could have, I mean, recently we're looking at two cases where it's a rear end crash. Both cars were totaled. Both plaintiffs went to the hospital. Both medical bills, were about $5,000 in total. And one adjuster through one carrier believes that 10,000 is enough, and then the other adjuster paid us almost 80,000. So, it really depends. A big factor is the adjuster and the insurance company. And so, those insurance companies that you see on TV a lot, your Allstates, your State Farms, etc., they've got it down almost to a science as to how much they're going to pay, and they don't care, and they'll just drag people through lawsuits and all that stuff just in order to save a few pennies. But at the end of the day, the jury system usually gets it right.
It usually does. And, it has to be frustrating, I would think, for the insurance defense bar to be in a world where they don't have any control over the things that they have primary responsibility for actually doing, both in terms of discovery and settlement discussions and so on. So how are your interactions with the attorneys on the defense side under the circumstances?
The one thing that I've really learned in this business is, and I think you can apply it to a lot of businesses, and I think Han would agree with me, is it's all about relationships. And even though, I'm going against the defense lawyer, I'm always friendly with a defense lawyer, unless there's a reason not to be. But for the most part, it's all a relationship, because you're working together to resolve a claim. And if my experience as a former defense lawyer, I know that the defense lawyer's job is basically to provide information to the carrier so the carrier can make a decision. If I can make that defense lawyer's job easier and have a good relationship with them, I think it bodes well for me. And I've had instances where, I've worked with a defense lawyer before in a case, and then we find ourselves together in another case, and they know I'm credible at what I do, and they just go, hey, here's my authority. I could nickel and dime you and get up to this, but here's the full authority. Can we get the deal done?
That because we hear so much talk about how lawyers, especially in litigation, are so uncivil toward one another. And yet that's almost always counterproductive. It's counterproductive in court. It's counterproductive in terms of getting a case resolved especially by settlement. So, where does this come from, I guess, is my question.
I really don't know. And there's very few attorneys that I don't get along with. And the biggest thing for me is dishonesty. And if I find that a lawyer's been lying, then can't trust him anymore, and it just kind of disintegrates from there. But for the most part, I think it's really important. And I think it helps the clients, because a lot of times you hear that, I want an aggressive bulldog who's not going to take any prisoners and all that stuff. Well, in reality, all you're doing is you're making it the case more difficult to resolve when you do that for a client. So I think the client benefits when there's a good relationship between the attorneys to make things work. And if everyone's on the same page and understands that, hey, this person was really hurt, this really needs to get resolved, then I think it works well for everybody.
And I would think, especially in a large urban area like Southern California, it is basically one big urban area from Ventura down to San Diego. There are so many lawyers that the personal touch isn't really there. So you have to establish rapport with a lot of new people all the time. Han, how do you find that? Are business litigators any different? Is there more or less civility? Do you see? Tell me about that.
Yeah, I would say the pool is a little bit bigger in my world. It's not as common to run into the same attorneys on the other side, although it will happen on occasion. But I do tend to agree with Oz as far as it makes a difference when you can get along with your opposing counsel, because the clients that we respectively represent, a lot of times they really hate each other. They have not just the business interests in mind, but there are emotional aspects. Especially if you're talking about family businesses, feuding relatives, that always adds an additional layer of complexity. And so you want to have the sort of rational and calm guidance of each respective counsel. And if they can get along with each other, then all of the attorneys can kind of do their jobs more easily. As you kind of mentioned earlier, it's not helpful when you have that attorney who thinks that the best strategy is to be as aggressive as possible, file as many motions to compel, serve a bunch of discovery for the sake of just causing paperwork that's not always productive in the long run. And so, I think it's important for counsel to try to understand what the goals are of each of the clients and the steps to get there, and not necessarily just focus on aggressive litigation, because that's not always the best way to achieve those goals.
It rarely is. It does make things more lucrative for the attorney's bottom line. And when you've got parties that are at each other's throat, they seem to be happy to pay those fees for, do whatever it takes to cause trouble to the other side. But it's almost always counterproductive.
Absolutely. And in a lot of situations that we see, we have clients that can't afford to defend or prosecute that type of aggressive litigation. So it's not just the desire to inflict pain, but whether you have the means or resources to do so. A lot of our clients they're small to medium-sized business owners. They're typically not used to having a litigation budget like an institutional client might have. And so the litigation that we're helping them try to resolve is usually the first time they're dealing with this in their lives and business lives. And so to them, the priority is not just resolving the case, but to be able to move on with their lives.
That makes perfect sense. And certainly with all the cases that I've mediated over the years, putting my mediator's hat on for a minute, in the business context, I was always seeing that need for the parties to get their set piece story out. Until they told that story, felt like somebody listened to them, weren't going to get anywhere with settlement. And, if they were at each other's throats, they were really angry, as you described, on one with the other. It was easy to remind them, the one thing you have in common is this dispute, and you're going to be dealing with each other until you get rid of the dispute. Oh, that was oftentimes the icebreaker. I stopped doing mediations of PI cases, way early on when I was mediating cases, because the insurance companies would show up with their claims adjuster with no authority. It's like, well, then why are we here? This is not, the rules are specific. You have to come with sufficient authority to settle a case. How does mediation work in that context?
Yeah, it's got to be the right time. And I'm shying away even from pre-litigation mediations because I find that more and more, the biggest thing for the insurance company is the trial date, because that creates pressure. And so when you haven't even filed a lawsuit yet, there's no really incentive for the insurance company to put its best foot forward. I find that typically the closer we are to a trial date, the better or the more money comes out. And even, for that matter, even outside the realm of mediation, even filing suit sometimes causes the insurance company to kick up more money because they know that there are firms out there that are just pre-litigation mill firms that will take whatever's put up before filing a lawsuit, and they would just want to pump and dump the case. And there's other firms like ours that say, okay, well, no, client, we think that if we filed suit, it's probably going to yield more money from the carrier because the carrier knows that, oh, all right, now they're escalating it. And sometimes, doing this for so long, especially on the defense side, is you'll get a different adjuster assigned when it's in litigation. And those adjusters aren't the new frontline baby adjusters. Those are the more experienced adjusters, have a little more authority to work with. And it's all strategically you're looking at as well. Are you dealing with an inside attorney's office where they're employees of the insurance company versus an outside firm where the bill is much higher? So you can use that kind of to your advantage. But going back to your question about mediation, it's, mediation, things have to be right. The insurance company has to have the information that they need. And sometimes that means getting your client deposed and providing them with the documents they need such that, they can be in the best position to evaluate the case.
So from your perspective, patience and persistence are two of the hallmarks of getting a good result, because you just have to wait it out until the time is opportune to do so.
Yeah, and sometimes it's harder for clients to understand that because the clients think, well, this person hit me, I was in a crosswalk, why don't they just pay me money? Well, unfortunately, there's a lot of people that try to commit fraud out there. And so this is why there's a process for the insurance company to do its investigation and make sure that what happened is really what happened. And we're happy to show it to them, but it takes time.
So Han, this has been going back to you and the business side of things. Both parties have a story to tell. And so facts come first, and discovery is all about, supposedly, it's supposed to be all about discovering the real facts. And once you understand the facts, even though each party may have a story associated with it, it should be easier to figure out what the outcome of the case should be, right? Isn't that the real purpose of discovery as opposed to how it's actually practiced?
Yeah, that's definitely, I think, the goal when the legislator drafted those statutes. How it's developed over the years in practice is certainly a different story, especially, with the advent of e-discovery, making it a lot easier for one side, for lack of a better term, to bury the other side in just mounds of emails, especially in the business context. That happens quite a bit. But in kind of tying back to the conversation about mediation, that's something that we try to recommend in the vast majority of our cases. And I would say over 90% of our cases resolve short of trial. But it's a process. As Oz mentioned, you have to learn what the facts are of your clients as well as the other side. And you need to engage in that discovery process, at least an initial written discovery, maybe a few depositions to learn the other side's story, so that all those facts are on the table to be able to make an informed decision to be able to go to mediation.
Has the use of software, the tools of e-discovery helped or made it worse, in your opinion, in terms of the amount of time it takes to get the facts, the ones that really matter, up on the table?
Probably both. It certainly made things easier, but it also, again, gives incentive to certain parties to use that process against the other side, right? Knowing that, all right, if we produce all of these emails, it's going to take the other side a lot of time to sift through them and find what's important. Maybe 90% of these emails being produced aren't relevant at all, but they are technically responsive. And so there's strategies that parties can implement, unfortunately, to take advantage of that to cause further delay, which is all part of the litigation process. But technology itself has improved a lot over the years. Since I first started out, it's made things a little bit easier. And I think with the advent of AI, it should try to speed up some of that process. And so that's something that's not going to go away, I don't think, anytime soon.
So what about document retention policies? Yeah, obviously today, especially in California, where suing is a sport, uh, in the business world, it seems, and we've got all these PAGA claims and so on. We have to have good management systems for what potentially tomorrow could become evidence. And so how often does this end up being a problem? I'll ask you first, because I know this comes up all the time in business, that, well, we can't find it, or we deleted it because we didn't have a proper retention policy or so on. And then you end up with a fight over discovery as opposed to what the facts of the case are all about.
Yeah, it can certainly be an issue. I would say in terms of the smaller businesses that are not used to litigation, a lot of times those types of cases come to us not at the beginning, but in the middle of a case. And so we weren't there to help them with the preservation issues. And so we're kind of dealing it in the middle and doing the best that we can. And so those situations are a little bit more difficult because you're dealing with maybe an entity that's not sophisticated when it comes to litigation. They're not aware of the rules of evidence and preservation. And so you can advise them from that point in time going forward as far as best practices. But in terms of the case that's in front of you, we just have to do the best that we can. It's a little bit easier when we get the case earlier on. So, for example, if we're hired to prosecute a case, we can provide a little bit more guidance to the client at that point as far as, okay, we need to see all of your emails. We need to see all of your document management and storage systems so we can understand not just what happened, but also where documents are stored and how they are saved and how they're communicated to outside parties and so on and so forth. So we have a little bit more control at the earlier stage of the case to help manage that process.
Right. And this is something that is only going to get worse in my view. Oz, do you have the same issue in dealing with tort litigation, particularly with personal injury? Do you have the same evidentiary issues? Does the other side do a pretty good job of coming up with the documents that are necessary?
Well, because we're prosecuting the case, I mean, the main documents you get from us, like let's just say for your everyday car accident, are you're going to have the police report, you're going to have photographs, you might have a video. There's more dash cams out there now, so you might have a video of it. You'll get medical records, medical bills, and then some documents to support any lost income. That's pretty much the universe of documents that we provide. The defense, I really, for the most part, I don't really care what the defense, provides. Although there are instances, if it's like a trip and fall case, where the retention issue comes in usually is with the video surveillance. Usually early on, if the video looks good for the defense, then we'll get it. They'll send it to us. They go, here, see what happened. But if it's bad for the defense, then it's usually the story is, well, we lost it, or that camera doesn't work, or it's just a decoy camera. But all the cameras over the registers usually work. No problem. So you can get fast and loose with that stuff on the defense. But what I find is that, and I don't know if Han would agree with this, but a lot of times the employees and the supervisors of the stores or whatever, they're never on the same page. And while there's a nice policy that's drafted by the attorneys and the execs to provide to these employees about what to do and what needs to be done, most of the time those policies are never followed. And we know how to do our examination or investigation such that all the employees are kind of all over the place, and so supervisors, so it usually works out good for us.
Yeah, I would tend to agree with that. As far as when it comes to institutional clients, a lot of times the bigger the organization gets, you have this situation where the left hand doesn't know what the right hand's doing, and that to the company's detriment, especially when the case comes to litigation. So if you're representing that particular client, it's certainly going to make your job more difficult. But if you're coming from Oz's side and prosecuting against that client, it's going to make things easier, hopefully.
So I want to ask about delay in the court. Certainly, COVID caused monumental disruption of all of everybody's systems, right? But courts in particular were hammered, and some haven't seemed to really recovered back to the point where you could get to trial in a timely manner. So how do you deal with delay in the courts? I'll go back to you on that
Sure.
first.
To the court's credit, COVID changed things in a way that, the old system was you either had to go to court and appear in person, and that could be for a hearing that lasts 30 seconds. You could drive from Orange County up to LA, sit in 2.5 hours of traffic, only to be at a hearing for 30 seconds and then drive all the way back home. Or you could do it on court call. But to the court's credit, and this is both LA County and Orange County at least, they set up the Zoom system. LA Court uses LA Court Connect, so it's really efficient way to get hearings done, and it saves on traffic, and it saves the environment a little bit. But the courts, in terms of delay, typically LA, you're going to get a trial date 1.5 years out from the date you file. Orange County, they'll have their initial conferences and then they'll set trials, and it kind of varies on the courtroom, but usually 18 months to 2 years, you'll have your trial date. So the courts have been doing pretty well, to their credit.
That isn't bad. I mean, it was certainly much longer following COVID for a while. Han, what about you? What have you seen?
Yeah, I definitely agree as far as the courts making it easier for attorneys to appear. That's certainly been a godsend for me personally, not having to go to Stanley Mosque for a case management conference. But as far as the delays, in terms of trial dates, I think it seems like they get pushed or continued a lot more often, even though it gets set. It's not always going to go forward on that date. Typically, departments, especially LA Superior Court, which is the largest court system in the nation, you have multiple trial dates scheduled for one specific date, and you don't really know which case is going to go forward until you get very close to that trial date, whether that's at the final status conference, that's a week to 10 days before the trial date, or the actual date of trial, which means that you'll have to continue to go and determine if you're trailing or not. And so if you're on the defense side, that certainly works to your advantage, because the name of the game there is delay, 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 try to get the plaintiff uninterested in the case, and in the meantime, cause them to spend more money on something that they don't want to be spending money on. So I think from the defense perspective, these court delays are beneficial. It can be frustrating when we're representing clients on the plaintiff side, because they're wondering, why is it taking so long for me to quote unquote get justice? And a lot of times we are having to explain, yes, we're doing the best that we can, we're following these motions, but at the end of the day, it's not up to us to decide when your matter is going to get heard. It really is dependent on that particular judge. And I do see that a lot of judges do things differently. Some of them are very proactive as far as setting initial trial dates at the initial or second case management conference, even if the case isn't at issue, because they know it's not going to go forward on that date. So you might as well just set it now, just to keep the ball moving forward. And they have more availability as far as law and motion calendars are concerned. But then you have other judges who don't mind kicking the can down the road, which works, again, to the defense benefit. So I think it really depends on the judge that you're assigned, and how much leeway that they're willing to give or not give.
If it's bad here, or it seems bad to the client, particularly someone who might have suffered an injury and really needs the money, it's only worse in some other parts of the country and other parts of the world. In 2003, a Texas company needed to sue a company in Pakistan over defective shipment of some generic drugs. That case was heard 17 years later.
Wow.
And then there still wasn't a ruling on it. But the fact that the case was finally heard allowed the parties to settle.
Wow.
17 years.
I don't know how you would go about going after a company in Pakistan. It almost seems like a lost cause.
Well, functionally, it usually is.
Yeah.
In this case, well, we have a lawyer, we filed a case, it's out of our hands. Someday something will happen, and that's what finally did happen. But if you're in an environment where you are unfamiliar, and for the typical business person or victim of an automobile accident, court is not your usual stomping grounds. It's all in the hands of the lawyers, and the judges control what goes on in the courtroom, and you sometimes wonder what you're doing there. So ladies and gentlemen, I want you to understand, by listening to two experts in their respective fields, you've got an overview of the system. And this is something that you need to take home and think about. If you're a business person, the last place you want to have a dispute resolved is in the court with a judge and 12 strangers deciding who's right and who's wrong, where you and your counterpart, as opposed as you might be, will have a better idea what the outcome should be. And Oz and people on the other side in the insurance defense industry will have a better idea of what your case is worth, even if it may take a while for it to get resolved, than you're likely to ever know, because there are lots of automobile accident cases. So there's a big pool of information that helps the parties evaluate what a case is worth. And sooner or later, the case will settle. If it's settleable, it's going to be within that range. Very few outliers, right, in settlement, Oz?
Yeah, if my mentality is, if you're going to trial, it's two reasons. One, either the plaintiff is asking way too much such that the insurance company is willing to roll the dice with a jury, or that the insurance company has misevaluated it somewhere and is offering too low, so it makes the client's decision easy. Because trial it's a risk. No matter how good you think the case is, there are so many factors that a jury could latch onto that could just, cut your knees out from under you. So a settlement, ultimately, at the end of the day, it's something more the defense wants to pay. It's something less than the plaintiff wants to take. But at the end of the day, you get certainty and resolution.
And Han, I would imagine that same thing kind of holds true in business litigation. It's usually the tough cases, the more outlier types, that end up going to trial, because that collective wisdom about what a settlement range that might be normal or reasonable is hard to find.
Yeah, I would say so. I think I mentioned before, I would say about over 90% of our cases will settle short of trial, because by that point in time, you have parties, both sides have spent a lot of money to get to that point. Most of it was, on litigation expenses, and they don't want to have to spend more to go to trial on something that's very uncertain, with too many factors in play. And so reasonable business minds typically will get to the point of resolution by that point. But every once in a while, there's that outlier, as you mentioned, in terms of, the one party just has that emotional component or psychological hurdle that they can't get past, and they want to be heard in court and have their day in court, risk be damned, and they have the resources to do so. So it's that kind of combination that isn't always in play for most of our clients, but every once in a while that's there, and they're willing to take that risk, and we'll help them go all the way with the trial.
Terrific. Well, Oz and Han, thank you very much for being my guests on today's episode of Professionals of the Inland Empire. A lot of valuable insights for our audience to take away. And thank you again for being on the show. So thanks, everybody, for listening in. So long for now from Professionals of the Inland Empire.
Thanks so much, John. Thanks, everyone.
John.
Thanks for watching or listening to, depending on the case, the Professionals of the Inland Empire show with your host, John W. Tulak. If you have a suggestion for a guest, email him at jwtulac, that's JWTULAC @gmail.com. jwtulac @gmail.com.